live at 9 p.m. We continue with Day 3 of the John Roberts confirmation hearings now, with senators each getting 20 minutes to ask questions of the nominee about his thoughts on cases, circuit court and Supreme Court decisions, and his approach to the law. This portion begins with questions by Senator Herb Kohl, Democrat of Wisconsin.
The committee will resume. Senator Kohl, 20 minutes.
Judge Roberts.
Senator.
We spent quite a bit of time yesterday discussing how you would decide cases, and as we all know, it is your view that Supreme Court justices are umpires who are neutrally deciding cases. I want to discuss with you another area where I believe your analogy falls somewhat short. Supreme Court not only, as you know, has the power to decide cases and to construe the Constitution, but it also has the sole and the absolute power to decide which cases it hears, which cases it decides, which parties get to be heard, and which parties do not get to be heard. So if you're confirmed, you will get to choose which cases will be placed on the Supreme Court's docket with the vote of yourself and only 3 other justices, as you know. Making this choice, your opinions, your perspectives, and your life experiences obviously matter quite a bit. Much more than an umpire calling balls and strikes, you are, in that sense, a manager who is really setting the field with players to decide what the menu is going to be like. So this power is really quite important, and it's crucial, and it's important that we understand that when we look at your role in terms of your own description. In recent times, the Supreme Court has received appeals in nearly 7,000 cases a year, and as you know, in recent times, the Supreme Court has heard only about 80 cases a year. In other words, the justices choose to hear only about 1% of the appeals that they receive. My question for you, Judge Roberts, is should you be confirmed, how will you decide which cases will make the cut and will be heard by the Supreme Court, and what will guide your complete discretion to choose which cases to hear?
I appreciate the question, Senator. It is an area where I will happily concede that the justices are not acting just like umpires in deciding which cases they're going to hear as opposed to how they're going to decide them. My perspective has changed a little bit in this area. Certainly when I was practicing law, a lot of what I spent my time trying to do was get the Supreme Court to take a case. As you know, you file these things called petitions for certiorari, which are really quite extensive arguments about why the court should hear your case, having really not that much to do with the merits, whether it was right or wrong, but just why the court needs to issue an opinion in this area. And I thought they weren't taking enough cases. When I became a Court of Appeals judge, I thought you didn't need to have more cases taken up for review. But the considerations, some are pretty well established. The job of the Supreme Court is to ensure the uniformity and consistency of federal law, in particular of interpretations of the Constitution. So the clearest case that the court should hear, they should grant certiorari on, as they say, is when two different courts of appeals are interpreting a law differently. Obviously, the law should mean the same thing in every part of the country, and if two different courts take a different view of the law, that's the kind of case the court ought to be taking. I think the court should, as a general matter, and again, other justices have expressed this view as well, grant review in cases in which a lower court strikes down an act of Congress. I don't think that's an absolute rule, but certainly as a general matter. If an act of Congress is going to be declared unconstitutional, I think the Supreme Court ought to be the one determining that as a final matter and generally not leave it to a court of appeals. So those are two categories, when there's a conflict, when an act is found to be unconstitutional. Beyond that, and this is where I agree with you, the umpire analogy does not hold up. There is a lot of discretion in deciding whether it's the right time to grant review in a case. The people who practice before the court talk about the court letting an issue percolate a little bit, in other words, get more than just one or two decisions from the courts of appeals, wait until others have had a chance to weigh in. The theory is that makes it more likely the Supreme Court will get it right if they have the benefit of several decisions from the lower courts rather than just one. Other cases, justices determine that that's not appropriate. It's not appropriate to wait till the issue develops a little more. They want to look at it expeditiously. And it's hard to lay down categorical rules in that area. I have expressed the view, and it may be a view that I'll have to be educated on further if I am confirmed, and I'm not stating it as a solid view. I do think there's room for the court to take more cases. They're here about half the number of cases they did 25 years ago. There may be good reasons for that I'll learn if I am confirmed, but just looking at it from the outside, I think they could contribute more to the clarity and uniformity of the law by taking more cases. I have heard others say they could contribute to the clarity and uniformity of the law by taking fewer cases, but I don't subscribe to that view. I think there's room for additional cases on the docket.
I think we agree that it's an enormous power, that power of decision. It's a very active power. It's not benign in any way. If justices, for example, decide not to hear a case, whatever the merits, that is the final decision. Is that not correct?
That's right. The decision of the Court of Appeals stands in that case. Now, it is true that I think the justices generally look at their duty and obligation to ensure consistency in a fairly dispassionate and objective way. In other words, it doesn't matter how a particular case came out. If it's different in one part of the country and another, most of the justices, in my experience, readily agree that that's the kind of case they need to address.
Well, just to refer to two that were taken up without any reference from any lower court. One was Youngstown Steel and Tool, which was, the ability of the government to seize a steel mill during a time of war. And of course, another one that I'm interested in your comment on is Bush v. Gore, in which the court decided to directly insert itself into a presidential campaign. I'm interested in not what happened after they decided to do that, but that the decision they made in terms of its propriety, its impact on the court standing in the country. You must have thought about it, I'm sure, a great deal when it happened. I'm sure you have an opinion on their decision to enter that case, and I think we'd like to know what that opinion is.
Well, you mentioned first the Youngstown case, and it's a category, and I think perhaps the Bush versus Gore case, perhaps the justices concluded it fell into that category. There are certain cases, they don't come along all that often, that are, by their importance, significant enough for the court to take. In other words, they don't fit the description of a conflict among the courts of appeals or an act of Congress held unconstitutional, but they are otherwise sufficiently important that the court will grant review and take those cases. Certainly, the Youngstown case was of that sort. It started out actually in the D.C. court, and the hearing was first there, and then the court granted that. But the decision by a president to seize the steel mills based on its constitutional, that's an important enough issue. You want the Supreme Court to issue a final ruling on that. On the decision in Bush versus Gore and the determination of whether to grant review in that case, again, that's not something that you don't know on what basis the justices make a decision to grant review. You just get an order that says review is granted. In that case, you had a decision of a state court that apparently the justices thought should be reviewed, and obviously expeditious treatment was needed, as I think it was in the Youngstown case as well. They're capable of moving expeditiously when an important matter requires them to do so.
I asked you what your opinion of that decision was at that time.
Well, that's an area where I've not felt free to comment, whether or not I agree with particular decisions or
well, it's not likely to come up again.
Well, I do think that the issue about the propriety of Supreme Court review and matters of disputed electoral contests, it is a matter that could come up again. Obviously, the particular parameters in that case won't, but it is a very recent precedent, and that type of a decision is one where I've thought it inappropriate to comment on whether I think they were correct or not.
Okay, Judge Roberts, one of the most important constitutional events of our lifetime was the nomination of Robert Bork to the Supreme Court. Congress chose to exercise its role to advise, and in this case not to consent, based upon judicial philosophy and the strongly held opinions of the nominee. In effect, Congress told the President that we have an important role to play in the process as well. Do you believe that the Senate's rejection of Judge Bork in 1987 was a reasonable and respectable act? Or instead, do you view it as a period of unfair partisanship? What were your thoughts about that case as it unfolded?
Senator, I don't think it's appropriate for me as a nominee to comment on the Senate's treatment of other nominees, and I would respectfully decline to do that.
All right. Judge Roberts, when we met a few weeks ago in my office, we discussed the Supreme Court's recent property rights decision. In that case, Kelo versus the City of New London, the court found it permissible under the Constitution for a city to seize private homes against the wishes of their owners so that a large pharmaceutical company could build a private industrial park and a research facility. A total of 15 homes were condemned, including a home lived in by an 87-year-old woman for her entire life, a home that her family had owned for over 100 years. Many people, including a majority, I believe, of people in my state as well as myself, were quite disturbed by this ruling, which appears to place much private property at risk by greatly expanding the eminent domain powers of, local government. We discussed this when you were in my office, and you told me that you were, quote, surprised by the decision. So could you expand on it a bit this afternoon and explain why you were surprised?
I did tell you that was my initial reaction. I remember hearing about the decision driving actually back from a judicial conference with another judge, and we all learn in law school, one of the first cases you study is called Calder against Bull. Has a basic proposition: the government cannot take property from A and give it to B. When I read the decision, I understood what the majority's position was, the difficulty of drawing a line between things that are obviously public use, like a railroad, a road, things that are traditionally the subject of the exercise of eminent domain, and other activities that are not as clearly within that range. Of course, Justice O'Connor, in her dissent, thought that a line could be drawn between whether it was available to the public or not, and that certainly was available. The majority did say that it was not ruling on the starkest example. In other words, just determining to take property from A to B because you think B could make better use of it. The issue arose, as you noted in your question, in the context of an urban renewal redevelopment project, and that may be limited to that context or may not. I do know there's been extensive legislative reaction to the decision. I know a number of states have passed laws already saying we do not authorize the use of the power of eminent domain to take for a use that's going to be from one private owner to another, and that's certainly an appropriate reaction to a court's decision in this area. What the court is saying, what the majority is saying, is because of the difficulty of drawing the line, this issue is really left up to the legislature, and if the legislature wants to draw the line in a particular place, it has that authority. But it certainly is a decision that was closely divided, 5-4, and it has gotten a lot of legislative reaction. And the point I would only make is that it's perhaps a good example of the fact that legislators have a responsibility to protect the rights of the people just as much as courts. And one way they can protect the rights of the people in this area, if they think it appropriate, is to restrict themselves in saying we will not use the eminent domain power to the broadest extent that the Supreme Court has said we are authorized to do.
Did I understand your opinion on whether or not that case was correctly decided, or are you not?
No, again, that's particularly since it's an area they do leave specifically leave open the question about whether it applies outside of a redevelopment project. That's an issue that could come before the court. It's not one I feel appropriate to comment on.
It would or would not surprise you if we've not heard the last of that?
It's certainly one of those areas that could come before the court again, even in its present form. I know the author of the majority opinion has said it was an area where he, as a personal policy matter, wouldn't have exercised that authority, but of course the issue there was the legal issue, not policy preferences. It could come before the court again, yes.
You'll have a decision to make if it does rise up to that level? Is it possible that your decision, along with 3 other justices, might be to put that on the docket?
That would be one of the decisions that, in the exercise of the cert process, as they call it, for short for the certiorari decision, and that would certainly be an issue that could come before the court. And they already have, of course, 4 dissenters who may be anxious to revisit it, or not. I don't know. I don't want to presume how they would view it on an ongoing basis.
Judge Roberts, I'd like to talk a little bit about antitrust. I'm the ranking member on the antitrust subcommittee. To me, antitrust is not some mysterious legal theory that only lawyers can talk about or understand. Antitrust is just another word for fair competition. The laws that we use to protect consumers and competitors from unfair and illegal trade practice is what antitrust is all about. You agree that government enforcement of antitrust laws is crucial to ensuring that consumers are protected from anti-competitive practices such as price fixing and illegal maintenance of monopolies?
Yes, I do, Senator. In fact, when I was in private practice, one of the cases I handled was the Microsoft antitrust case on behalf of government officials, the states in particular. A number of states retained me to argue that case before the D.C. Circuit en banc. So I certainly appreciate the role of governments, both state and federal, in enforcing the protections of the antitrust laws, because, as you know, there is concurrent authority in that area. The Sherman Act, of course, on the federal level, and then what people call the baby Sherman Acts on the state level.
I'm glad to hear you say that, because on June 14, 1983, which is more than 20 years ago, in a memo to the White House counsel Fred Fielding, you wrote, quote, "Enforcement of federal rights is advanced most effectively by private suits in antitrust cases." So, isn't it often true that individual consumers don't have the resources to pursue these private suits against large corporations? And isn't that why government enforcement of antitrust is essential? And so you would perhaps not be feeling the same way today as you did 22 years ago when you made that comment?
Well, I think it depends on what area you're talking about. I do think that the system established under the Sherman Act of private antitrust enforcement, and of course the opportunity to recover additional damages and attorney's fees and other aspects has been an effective tool in enforcing the law. There are areas, as you mentioned, if the issue is mostly consumer rights as opposed to business rivals, that the government action may be more necessary in those areas as opposed to the others. And I know that government antitrust regulators make those determinations every day, that their resources are best directed to areas where consumers or attorneys bringing class actions on consumers' behalf, whatever the reasons, where the incentive system for private litigation may not be as effective. And that's often the area where state attorneys general, the Justice Department decide to get involved to supplement the private enforcement activity.
All right. I'll just ask one more question before my time expires, and that's upon the important role that Chief Justice plays as the head of Judicial Conference, which is the organization of the entire federal judiciary. As head of Judicial Conference, Chief Justice makes policy recommendations as a legal reform, with respect to legal reform, reform of court procedures, and advocates for the federal courts. What, if you were confirmed, would be your agenda, your plans, or your policy objectives to advance in connection with your role as the head of Judicial Conference?
Well, I am familiar with how the Judicial Conference operates for at least part of its role. I've been on the Advisory Committee on Appellate Rules. I was there as a lawyer, and I was kept on as a judge. In fact, I was slated to be the chairman of that committee starting in October. So I understand the role in promoting reform of rules that apply in the federal courts, both the appellate rules, the civil rules, criminal rules, and bankruptcy rules and evidence rules, different committees there. And I'm familiar with the process. They go through the advisory committee, a broader committee about rules in general, then they're submitted to the Judicial Conference for consideration. And it's a very exhaustive process, but I think also a very responsive one. Particular problems are identified in practice by practitioners, by judges. They're submitted to the committees. They review them. They come up with proposals. It's a very important part of the functioning of the federal system, and it affects all the levels, not just the Supreme Court, of course, but the courts of appeals and the trial courts. Other issues of concern, obviously, pressing issues, concerns with respect to security in light of different developments, those are addressed at the Judicial Conference. Any need for legislative action that the courts feel is appropriate. I have to tell you that if I were to be confirmed as an initial matter, I think my primary posture is going to be one of listening because there's obviously much I have to learn about matters of concern to different judges, different courts around the country. And that's the good thing about the Judicial Conference, of course. They bring in judges from around the country to make sure that you get a national perspective on what needs to be done, and you're not just focused on issues here in Washington or anywhere else. But it's an area where I think I will have to listen a lot at the outset before being presumptuous enough to have a particular agenda.
I thank you, Judge Roberts. I thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator Kroll. Senator DeWine.
Thank you, Mr. Chairman. Judge, good afternoon.
Good afternoon.
You know, Judge, our Constitution created federal courts with limited powers. In fact, Article 3 of the Constitution only gives the federal courts the power to decide cases and controversies. This case and controversy requirement means that federal courts will only hear real lawsuits involving real parties with real injuries. You've talked about this in the last several days. This has led to the development of a number of different rules about when people can bring lawsuits in federal court and when they cannot. One of these rules, as you well know, is the principle of standing. You talked about this in 1993 in a law review article you wrote in the Duke Law Journal. You said the following, I'm going to quote briefly from this. The legitimacy of an unelected, life-tenured judiciary in our democratic republic is bolstered by the constitutional limitation of that judiciary's power in Article 3 to actual cases and controversies. You went on later to state the following. The Article 3 standing requirement ensures that the court is carrying out its function of deciding a case or controversy rather than fulfilling the executive's responsibility of taking care that the laws be faithfully executed. End of quote. Judge, could you elaborate on these statements today and maybe explain briefly what the doctrine of standing is and why that doctrine is really so important to our constitutional system?
Well, Senator, your question really ties together a few themes we've already touched on. I don't remember if it was you or someone else who referenced Justice White's description of his obligation and what it was, and his answer was to decide cases.
That was me.
And the basis for the institution of judicial review, as explained by Chief Justice John Marshall in Marbury v. Madison, is similarly grounded on the obligation to decide cases and controversies. Because if you look at the Constitution, it doesn't say in Article 3 that the judicial branch is established in order to tell us all what the Constitution means. It says that the judicial branch is established to decide cases and controversies arising under this Constitution and the laws. And that is the basis for the authority to interpret the Constitution. As Marshall explained, we have to decide a case. If the argument is that it's inconsistent with the Constitution, we have to decide that. Therefore, we have that authority, and I believe that's consistent with the intent of the framers. But it does mean, and this is the point I was trying to make in that small little law review comment, that judges should be very careful to make sure they've got a real case or controversy before them, because that is the sole basis for the legitimacy of them acting in the manner they do in a democratic republic. They're not accountable to the people. As judges, they have the obligation to decide cases according to the rule of law. So first, make sure you've got a real case. And a real case is not simply, you know, I'm interested in this area, I don't like what the government's doing, or I don't like this law, and so I'm going to go to court. What the standing doctrine requires is that you actually be injured by what the government is doing, injured by Congress's action. Now, the injury doesn't have to be economic. The Supreme Court has explained in cases like Sierra Club versus Morton, it can be aesthetic, it can be environmental, it can cover a wide range of injuries. But you do have to show some injury that separates you from the general public. So you're just not voicing a gripe, you're trying to get a case decided. That's the importance of the standing doctrine.
I appreciate the explanation, Judge. Let me ask you a more personal question. Last time you appeared before our committee, you were a lawyer in private practice. Since that time, you've spent approximately 2 years on the Court of Appeals for the District of Columbia. New experience for even an experienced practitioner like you. What surprised you about the last 2 years of judging?
Well,
if anything.
Well, I think I had the biggest surprise on the first day that I heard cases. Obviously, it's opening day and first day in my career, so I prepared as well as I could. The arguments were great, and I went into the conference room and I had my notes and all the books. It's just the judges, you know, just the 3 judges. We bring the record in. We're surrounded by the U.S. reports, by our Court of Appeals reports, by the United States Code that you folks have written. And I was ready, and I'm sitting there, and I remember the Chief Judge, who by tradition sits on a new judge's first day, and he was there, and another judge, and I waited a while, and I looked, and they were still waiting. I waited a while longer, and they were still waiting, and finally the Chief Judge advised me that the tradition was that the junior judge goes first at these discussions. And so I was kind of put on the spot right off the bat. And part of what that conference was like, and throughout, really has, I don't know if I'd say a surprise, but it's been illuminating to me. The judges really do roll up their sleeves and try to find the right answer. It's just the judges. But as we say, well, we think this case is controlled by the Smith case, we get out the Smith case. We open it up and we look at it. We're reading over each other's shoulders and see exactly what it says. If somebody says, well, but in this case, under the record, there was no evidence about this, or there was no objection raised about that. Well, you get out the record and you look, and there at page 223, you point to it and say, well, here's where the objection was raised. And the judges are very open. It's a very encouraging part of the process from my point of view. Nobody goes in there with set views. They want the benefit of the collegial process, the benefit of each other's views, and you have to be able to substantiate your position. There's no place for rhetoric. People are pointing to the law. And I found that a very encouraging part of the process, what goes on in the conference room, which was, of course, a part of the process that I hadn't participated in before.
That's something that we don't see either.
Right.
No way of seeing it.
Right. And the positive part of that process to me was that nobody was invested in anything other than getting the right result. And they're prepared to be convinced, contrary to initial impressions, and I was as well. I found a very encouraging part of the process.
Judge, let me ask you, moving to the administrative law issue, if I could. As you know, in the 18th and 19th centuries, we really did not have governmental agencies that have such a profound influence, for better or worse, on the lives of Americans today, daily lives of Americans. Today, administrative agencies set workplace safety rules, establish environmental regulations, lay down traffic safety standards, just to name a few things. But as far as I know, there's no specific article in the Constitution dedicated to the administrative state that we live in today. In your view, what is there in the text or history of the Constitution that supports the growth of this administrative state that we live in? Is the growth of the administrative state an example of the Constitution being amended simply out of necessity, or is the administrative state consistent with the Constitution as drafted by our founding fathers? How do we get to where we are from a constitutional point of view?
Well, you know, we all, of course, begin in high school civics with the notion of three branches of government: the executive, the legislative, and the judicial, and we study that, and then only occasionally do people look at the real world and see, well, what is this agency? What is that? Is that legislative, or is that judicial, or is that executive? And of course, the answer is, well, it's a little bit of each. It's exercising power delegated by Congress. It's executing it in a particular way. It's issuing regulations that have the force and effect of law, and quite often it's adjudicating particular disputes. The activities of the administrative agencies are, of course, the bulk of what the judges on the Court of Appeals for the D.C. Circuit do, and the principles of administrative law that have recognized the legitimacy of these agencies and sought to ensure that their exercise of authority is consistent with constitutional provisions by basically, I mean, I know the issue can seem arcane to many people, but the fundamentals of administrative law really go back to the basic principles of justice. Is someone being given an opportunity to be heard? Is someone being treated fairly? Is someone who's making a decision doing it for a rational reason or an arbitrary reason? These are the same basic principles that have animated the common law system since the time of Lord Coke, and they're being applied here as well. And the objection is often, this agency made a decision without adequately hearing our concerns, or this agency made an adjudicatory decision without hearing the record evidence, or they did not explain. That's the basic requirement of administrative law. Explain your decision. That's the limitation on arbitrariness. And the agency didn't explain why it's doing this. The notion that even in these arcane areas, our legal system insists upon the observance of these basic requirements of, I don't want to use it, say, due process as a technical term, but that's the principle that is being applied. That goes a long way to explaining how these agencies have been accepted into the constitutional system, because they've been required under principles of administrative law to comply with these basic precepts of procedural regularity.
Judge, let me turn to the area of antitrust, a matter that's very important for the businesses and consumers of this country. For over 100 years, our antitrust laws have helped consumers by ensuring that our economy is competitive and vibrant. Our antitrust laws are the oldest in the world, and many and people, including me, think they're the best in the world. In fact, I'm proud to say that John Sherman, Republican senator from my own home state of Ohio, wrote the first antitrust law back in 1890. Over the past 20 years, we've achieved a great deal of consensus, I think, about how the antitrust laws should be enforced, Democrat and Republican administrations. As the chair of this subcommittee on antitrust, competition, policy, and consumer rights, I've worked very closely with Senator Cole, who asked you some questions about antitrust. I think we've worked in a bipartisan way to ensure that consumers and competition are protected. It's a simple goal, but it's not so always easy to achieve or put into practice. For example, recently the rise and expansion of the Internet and the technological explosion of the so-called new economy have led to a marketplace that's changing faster and more often than we have really ever experienced before. Judge, what challenges do you think the courts face in trying to square our old antitrust laws as they're currently written with new business strategies in the high technology markets? And do you think that these laws give courts enough guidance to deal with these new economy issues?
Well, that was really the basic issue that I faced in the Microsoft case before the D.C. Circuit en banc. There was a lot of argument, academic commentary back and forth, the idea this is a whole new area, you can't apply the old principles, they don't work in this context, you need to do something different, the so-called new paradigm and all that. And at least the argument that I tried to make on behalf of the states was that the basic principles are the same. The Sherman Act was, as many have said, you know, a charter of economic freedom, and that those basic principles do have to be applied regardless of changes in the economics of the underlying businesses or the structure of the markets. Obviously, it requires a great deal of sensitivity on the part of the judges, and it's a real challenge for the lawyers sometimes to be able to understand the economics, to be able to explain them to the judges, and judges appreciate that. But my basic instinct, and it's nothing more than that, is that the principles are there, and the issue is simply application in a new context.
Good. Great. Thank you. Judge, just one final comment. Yesterday, Senator Grassley asked you whether you think that there is, and I quote, any room in constitutional interpretation for the judge's own values or beliefs. In response, you said, and I quote, "No, I don't think there is. Sometimes it's hard to give meaning to a constitutional term in a particular case, but you don't look to your own values and beliefs. You look outside yourself to other sources." End of quote. You continued by saying that, and I quote, "Judges wear black robes because it doesn't matter who they are as individuals. That's not going to shape their decision. It's their understanding of the law that will shape their decision." End of quote. Now, Judge, I know what you meant by that answer. Judges should not impose their own preferences from the bench. In fact, I said pretty much the same thing in my opening statement on Monday. But, Judge, putting on a black robe does not mean that a judge should lose his character. You, sir, have a perfect resume and certainly an outstanding professional career. But a Supreme Court justice is more than just impeccable academic credentials and impressive accomplishments. President Bush nominated John Roberts the man. America has gotten to know John Roberts the man. And I'm quite sure that the Senate is, in fact, going to confirm John Roberts the man. Over the past several months, we've examined your life, met with you in private, and now question you about your beliefs. Throughout this time, your honesty, your integrity, your wisdom, your judgment, and dare I say, yes, your values have shown through. I would just say, sir, please don't check any of that at the door when you walk into the Supreme Court. By becoming John Roberts, the Chief Justice, don't ever forget to be John Roberts, the man. I think this country needs you to remember how you got here and who you met along the way. We need you to bring to the court your compassion and your understanding for the lives of others who haven't been as successful as you have been. We need you to bring to the court your strong commitment to equal justice for all. And we need you to always remember that your decisions will make a real difference in the lives of real people. When you put on that black robe and assume your spot on the Supreme Court, you will truly bring with you your heart and your soul. The values you learned from your parents and others that you learned as you grew up in the wide open fields of your youth. Those values are strong, they are true. The President saw them when he nominated you, and we have certainly seen them this week. And I must say, sir, that they must never leave you. Justice Felix Frankfurter gave this same advice to his colleagues in 1949. There comes a point, Justice Frankfurter wrote, where this court should not be ignorant as judges of what we know as men. Great justices are more than just legal automatons, legal technicians. They're more than just that. And though they lose their individuality when they put on a black robe, great justices never forget who they are. I wish you well. Thank you, sir.
Thank you, Senator.
Thank you very much, Senator DeWine. Senator Feinstein.
Thank you very much, Mr. Chairman. Judge, I subscribe to much of what Senator DeWine said. I want to tell you what I think, perhaps a little differently and personally. Senator Graham last night pointed out that Justice Scalia was confirmed by 98 votes of this body. And I thought then, and I think now, how different the days were in 1986. There's so much water under the dam since then. The nation is divided. It's polarized. That's about 50-50. We're at war. Executive authority is very much on people's minds. The law, as it relates to war, the Geneva Conventions, the Conventions Against Torture, all of these things, very much on everyone's minds. We've seen in the last 10 years 193 5-4 decisions of the court, which suggests that on major questions, the court is also very divided. And so in comes this young justice. I was one on our side that voted for you for the D.C. court. I did so because there were so many testimonials about what a fine lawyer you are, what a fine human being you are, and I voted for you. But there's more in this vote. Senator DeWine just spoke about the man as opposed to the legal automaton. Yesterday morning, you spoke, I thought, eloquently in answering Senator Specter's questions on Roe. You discussed stare decisis as fully as I have ever heard it discussed. I'm not a lawyer. I learned a lot from listening to you. You discussed the right to privacy. You were very full and forward-speaking. And then after lunch, it was as if you shut down and became very cautious. So my first question, did anybody caution you between the morning and the afternoon sessions?
No, Senator, no.
Has anyone, when you were being interviewed for this position, ever asked your opinion on Roe?
No.
Okay, that's good to know. 1973, 2005, 32 years, over 3 generations of women have come really to feel that finally they have some autonomy over their body. And, you know, women are all different. Many of them are very pro-life. Many are pro-choice. People have different religious views, moral views. So it's this big, diverse cosmopolitan of women. But the growth has been enormous. And the ability of women to succeed, I mean, I went into the workforce at the same time Sandra Day O'Connor did with a year's graduate work. The door was closed. It's now open. And women are so lucky. And it seems to me that the living Constitution is that each person in this great country, man or woman, you know, rich or poor, white or black, whatever it might be, can really reach their full potential. And I guess what has begun to concern me a little bit is Judge Roberts, the legal automaton, as opposed to Judge Roberts, the man, because I've heard so many times, you know, I can't really say because it may come before me. And yet I don't expect you to say what you would do with Roe, one way or another. But I do expect to know a little bit more about how you feel and how you think as a man, because you're a very young man to be Chief Justice. You could be Chief Justice for 40 years. That's a very long time. And because of the division, and there's also a lot of fear out there where this new court, now with potentially 2 new justices, is going to go. Whether you've got the ability to bring that court together, to end the 5-4 decisions, to see that big decisions are made so that they represent a much greater consensus. And I'm trying to find out and see, are those qualities really there? I was interested in a colloquy you had with Senator Biden on the end of life, and he used the word, he asked a number of legal questions, and then he says, okay, just talk to me as a father and tell me. Now, I've been through 2 end-of-life situations, one with my husband, one with my father, both suffering terrible cancers, a lot of pain, enormous debilitation. Let me ask this question this way. If you were in that situation with someone you deeply love and you saw the suffering, who would you want to listen to? Your doctor or the government telling you what to do? To me, it's that stark because I've been through it.
Well, Senator, in that situation, obviously you want to talk and take into account the views and the heartfelt concerns of the loved one that you're trying to help in that situation, because you know how they're viewing this. You know what they mean when they're saying things like what their wishes are and their concerns are. And of course, consulting with their physician. But it seems to me that in that situation, you do want to understand and make sure that you appreciate the views of the loved one. And only you can do it because...
That wasn't my question.
I'm sorry.
I'm trying to see your feelings as a man. I'm not asking you for a legal view.
Well, I wasn't trying to give a legal view. My point was that obviously you look to the views of the person involved, and if it's a loved one, you are the one who is in a position to make sure that you understand their views and can help them communicate those.
How would you feel if you were in that position?
An end-of-life situation and suffering, you know, I do think it's one of those things that it's hard to conceptualize until you're there. I really would be hesitant to say this is what I would definitely want done or that's what I would definitely want done. You do need to confront that and appreciate all of the different concerns and impulses and considerations.
And every situation is different.
Yes. And it's one of those things I think it's difficult to put yourself in that position and saying, well, with any degree of confidence, if I were suffering and confronting the end of life, this is what I would want to do, or that is what I would want to do. You can theorize it and try to come up with your views or how you would confront...
That's right. All I'm saying is you wouldn't want the government telling you what to do.
Well, I'm happy to say that as a general matter.
That there should be a basic right of privacy.
Well, that's getting into a legal question,
okay,
and you don't
want... I won't go there. Let me go somewhere else. Commerce Clause, the 14th Amendment. Lopez, which began a chain of about 36 cases, striking down major pieces of legislation. It's not easy to get a bill passed here. I mean, there are hearings, there are discussions, there are markups. There's one house, there's another house, there's a president. It goes through most of the time, scrubbed pretty good before it gets to the president. Gun-free schools, struck down in 1995. An impermissible use of the Commerce Clause. 96, Moses Lake, Washington, shooting in a school. 97, Bethel, Alaska, principal and one student killed. 97, Pearl, Mississippi, 2 students killed and 7 wounded by a 16-year-old. 1997, West Paducah, 3 students killed, 5 wounded. Stamps, Arkansas, 2 students wounded. Jonesboro, 98, 4 students, 1 teacher killed, 10 others wounded outside West Side Middle School. Edinburgh, Pennsylvania, 1 teacher killed, 2 students, and on and on and on. An impermissible use of the Commerce Clause to prohibit possession of a weapon in schools. Now, at what point does crime influence commerce?
Well, I think it does. And one of the things that's important to understand about the Lopez decision as the court analyzed it, and again, I'm not taking a position on whether it was correctly decided or not, but as the court analyzed it, one of the things about the act was that it did not have what's known as a jurisdictional requirement. It didn't have a requirement that the firearm be transported in interstate commerce. A requirement that I would think it would be easy to meet in most cases because gun...
But the firearm is transported in interstate commerce. Maybe not when that student had it, but to get to the student, the firearm has been transported in interstate commerce.
My point is that the fix in Lopez, all that the court was saying was missing in there, or what was different about Lopez than many of the other cases, was that lack of a jurisdictional requirement. And if the act had been, as I understand the court's analysis, if the act had required that, which I think, again, it's fairly easy to show in almost every case. As you say, these guns are transported in interstate commerce. Then that would have been within the Congress's power under the Commerce Clause. I think it was an unusual feature of the legislation that it didn't have that requirement, as so many laws do. As you know, it often says, you know, in interstate commerce. And that's, at least as I understand the Lopez decision, what made it unusual.
That's very helpful. You might get it back again someday with that fix. Let me turn to something else that Senator Leahy asked a number of questions on, and that's the Constitution and executive power. I'm looking for the section, but the Constitution very clearly says that any treaty is treated as the supreme law of the land, right? And that no state or official can abrogate it.
Right.
Which gives it the total weight of law. Can a president then decide not to follow a treaty?
As a general matter, the answer is no. The treaty power, as long as it's ratified according to the requirements in the Constitution by 2/3 of the Senate, you're perfectly correct. It is under the Supremacy Clause, the supreme law of the land. Now, I don't know if there are particular arguments about executive authority in that area with which I'm not familiar, and I don't mean to state categorically, but my general understanding is that treaties that are ratified, and of course we have treaties that aren't ratified and executive agreements that aren't submitted for ratification and so on, but a treaty that's ratified by the Senate under the Supremacy Clause is part of the supreme law of the land. Now,
so the conventions against torture and the Geneva Conventions would apply?
yes. Now, there are questions, of course, that arise under those and have arisen under those about interpreting the conventions and how they apply in particular cases to non-parties to the convention and so on. And as you know, those cases have been coming up and are being litigated. But that's an issue of what the convention means in a particular case, not whether, as a general matter, a treaty is binding.
Let me take you to the morning, yesterday morning in stare decisis, because you specifically discussed, when you were asked about Roe and Casey, precedent, specifically, as we said, workability, reliance, pragmatic considerations, changed facts or circumstances, and whether the underlying legal or constitutional doctrine would still be valid. Are there any other factors that you think should be considered?
Well, the Court has been somewhat inconsistent on some other factors. They, for example, talk about, in some cases, the length of a precedent, the idea that the longer it's been on the books, the more people have conformed their conduct to it. In other cases, they've suggested that's not such an important consideration. In Payne versus Tennessee, the case that it noted how closely divided the Court was in the prior case as a factor. But in other cases, the Court has said that's not a major consideration. So I put those factors on the table simply because in some cases the Court looks to them, in others it doesn't. But I think the ones I mentioned yesterday are ones that apply in every case, including the settled expectations, the workability, whether the doctrinal bases of a decision have been eroded.
Yesterday, in answering Senator Specter on this very point, when you referred to Payne v. Tennessee, you did point out there were other considerations that come into play, and they're laid out again in Dickerson and in other cases, Payne v. Tennessee, Agostini, and a variety of decisions where the Court has explained when it will revisit a precedent and when it will not.
Yes.
What do you think, when it should and should not?
Well, I do think you do have to look at those criteria, and the ones that I pull from those various cases are, first of all, the basic principle that it's not enough that you think the decision was wrongly decided. That's not enough to justify revisiting it. Otherwise, there'd be no role for precedent, no role for stare decisis. Second of all, one basis for reconsidering it is the issue of workability. If a precedent has turned out not to provide workable rules, if courts get different results in the similar cases because the...
Or if another case, like Casey, finds that Roe is workable.
Well, again, that's a different, that is a precedent of its own, right, that obviously would be looked at under principles of stare decisis. The issue of the erosion of precedent, if you have a decision that's based on 3 different cases and 2 of them have been overruled, maybe that's a basis that justifies revisiting the prior precedent. The issue of settled expectations, the Court has explained, you look at the extent to which people have conformed their conduct to the rule and have developed settled expectations in connection with it. Perhaps the discussion earlier we had about the Dickerson case is a good example of that, where the Chief Justice just thought Miranda was wrongly decided, but explained that it had become part of the established rules of police conduct, and he was going to respect those expectations.
Now, yesterday you said this: I agree with the Griswold Court's conclusion that marital privacy extends to contraception and availability of that. The Court, since Griswold, has grounded the privacy right discussed in that case in the liberty interest protected under the Due Process Clause. Do you think that right of privacy that you're talking about there extends to single people as well as married people?
But the courts held that in the Eisenstadt case, which came shortly after Griswold, largely under of equal protection, and I don't have any quarrel with that conclusion in Eisenstadt.
So, okay, do you think that that same right extends beyond family choices then about a child's education?
Well, that's where it actually got started 80 years ago in the earliest cases. Meyer and Pierce involved questions about how to raise children, whether you could teach them a foreign language, whether you could send them to a private school. And those decisions are really what started that body of law.
I have another question I could ask, but you won't answer it, unless...
We'll give it a try, Diane. Go ahead.
Well, does it cover the right of a woman to decide whether to continue her pregnancy?
Well, Senator, as I've explained, that is an area
they have to come before you, and you right. That message was well conveyed. Could I ask you a couple of, one question, I think I'll have time, in Acre v. the Republic of Iraq.
Yes.
This was the case where 17 U.S. prisoners, they were our people, suffered severe beatings, starvation, mock executions, dark and unsanitary living conditions, etc., during the first Gulf War, and they sued the government of Iraq, the Iraqi intelligence services, and Saddam Hussein for their brutal and inhumane treatment. The veterans won their case in district court in July of '03. They were awarded $959 million in damages. After the judgment, the Justice Department intervened in the suit to contest the district court's jurisdiction. The specific issue involved a statutory interpretation of the Emergency Wartime Supplemental Appropriations Act passed in 2003. Justice argued that the statute gave the President the authority to change Iraq's designation as a state sponsor of terror and thereby relieve it after the fact of its responsibilities for prior acts of terror. You wrote a concurring opinion in favor of overturning the district court's judgment. Although you agreed with the other two judges on the panel that the judgment should be reversed, you alone adopted the Department of Justice's argument that the statute granted the President total power to absolve Iraq of liability. You reached this conclusion while acknowledging that the question of statutory interpretation is close. Could I ask my question?
Yes, you may finish your question.
Do you believe that when, as in Acre, there's a close question of interpretation of a statute touching upon a foreign policy, that the executive deserves total deference?
Oh, no, Senator. Whether the question is close or not, I don't think there's any situation where a court concludes that the executive deserves total deference, and that was not the basis of my decision. The judges were unanimous that the veterans were not entitled to relief. The panel was chosen from happened to be appointees of 3 different presidents. The view was unanimous that they were not entitled to relief. The other 2 judges concluded there was no cause of action available to them. I concluded that there was no jurisdiction and wrote separately. The recognition that it was a close question is also reflected in the view of the other 2 judges in addressing my concern. They acknowledged that it was a close question, and I agreed with that. But you did have legislation that said that the President can determine that these laws do not apply if he makes a determination under the criteria set forth in the statute. And he had done that, and my conclusion that that extended to the provision that otherwise would have allowed suit. The other 2 judges disagreed. They thought there was jurisdiction, but then concluded there was no right of action. So the end result of both of our position was the same. But it was not a question of deference. It was a question of interpreting the legal authority and consequences of an act that this body had passed and the President's finding under that. When it comes to interpreting questions of law, I go back to the Marbury versus Madison. That is emphatically the province and duty of the judicial branch. We don't defer to the executive. We don't defer to the legislature in making that final decision about what the law is.
To get confirmed, maybe you'll defer to the legislative a little bit. Thank you.
We defer,
Thank you,
just to clarify, we certainly defer in the standards of review that make sure that we're not infringing. But the final decision about what's constitutional or not rests with the judicial branch. The policy judgments, we certainly defer to the legislature.
Thank you.
Thank you.
Thank you, Senator Feinstein. Senator Sessions.
Thank you, Mr. Chairman, and thank you for your leadership as we move forward expeditiously, I think, today, and I think in a helpful way. I think the hearings have been very good, and Judge Roberts, I salute you for your excellent manner and your forthrightness and professionalism as you answer these questions. You know, I hope we are moving away, Senator Feinstein, from divisiveness. So we've got in some ways we do have a divided country, but in other ways I think we have the potential to move together. And I frankly believe that one thing that causes divisiveness and frustration and angst is when a Supreme Court were to render an opinion that really is more a political or social policy decision rather than a legal decision. And when they say it amounts to the Constitution, a constitutional provision, then that Supreme Court opinion can only be changed by 2/3 of both houses and 3/4 of the state. Do you understand that danger, Judge Roberts, in opinions, and is that perhaps one reason you think a judge should show modesty?
Well, it's part of what I mean when I say a certain humility should characterize the judicial function. Judges need to appreciate that the legitimacy of their action is confined to interpreting the law and not making it. And if they exceed that function and start making the law, I do think that raises legitimate concerns about the legitimacy of their authority to do that.
Well, I would observe that the American people are beginning to believe that is occurring, and I think it does threaten the legitimacy of the court in a way that all of us who love the law should be concerned. And I do love the law, and I'm a big critic of the courts on these kind of activist cases, but I have practiced full-time before federal judges, and as I said earlier, I believe day after day justice is done. You have said that in your before your court, you're impressed with the objectivity and fairness that the judges bring. Is the ideal of blindfolded justice a neutral umpire? Is that a romantic, naive ideal, or is that something that you believe we can and should strive to achieve in America?
Well, I do know that there are sophisticated academic theorists, people who spend a lot more time theorizing in this area than I do, and a lot smarter than I am addressing these issues, some of whom conclude that in particular cases it's difficult to do, it's difficult to avoid making the law while you're interpreting it, and they kind of throw up their hands and suggest that we shouldn't even try, therefore. And I don't agree with that. I think as a practical matter, as a pragmatic matter, judges every day know the difference between interpreting the law and making the law. Every day, judges put aside their personal views and beliefs and apply the law, whether the result is one they would agree with as a legislator or not agree with. The question is what the law is, not what they think it should be. I've seen that on the Court of Appeals. I've seen that as a practicing lawyer before the court. That is the ideal. I'm sure judges, I'm sure justices don't always achieve it in every case because it's a human endeavor, and error is going to affect any human endeavor. But that is the ideal, and I think good judges working hard can not only achieve it, but also achieve it together in a collegial way and benefit from the insight and views of each other.
Well, I thank you for that, and I would share those views, and I absolutely believe the strength of our nation is our good legal system. We've talked about the Commerce Clause, and there's been a lot of criticism of some of the cases. I think there have only been two significant Commerce Clause cases maybe in the last 40 years, Lopez and Morrison's. Senator Feinstein and you had a nice exchange about Lopez. I would certainly agree with your analysis. Had the Congress placed in there a requirement that the firearm had been traveled in interstate commerce, I believe that statute would have been upheld. We could pass it again with that simple requirement, and virtually every state, virtually every firearm will have traveled in interstate commerce. A few states have manufacturers. when I was a federal prosecutor, I prosecuted a lot of those cases. As a young prosecutor, I was sort of an expert at it in the 70s, and I proved sometimes the interstate commerce by simply putting an agent on the saying there was no gun manufacturer in Alabama, or it said made in Italy on it. I remember got that affirmed one time as a proof beyond a reasonable doubt that it was not made in Alabama. So Lopez, I believe, is a good decision. Also, with regard to crime, I would note that we've always had that nexus with interstate commerce. As a federal prosecutor, it's not a prosecution for theft. It's prosecution for interstate transportation of stolen property. That's the federal crime. Theft is prosecuted only by the state courts, unless it's from a theft from an interstate shipment. That's a federal crime. It's not a stealing an automobile. It's interstate transportation of a stolen motor vehicle. The ITSMV is the federal crime. The Hobbs Act, the Extortion Act, to use against politicians, you have to have an interstate nexus. And I've had cases where bribery was proven, but we were not able to prosecute it federally because it did not have an interstate nexus. RICO, even arson cases have to have it there. And so I just want to make sure that let me ask you this, in general, wouldn't you agree that if someone in Pennsylvania picks up a rock and murders their neighbor, that is a crime unreachable by federal prosecution under traditional interpretations of Commerce Clause and the reach of the federal government?
Well, again, barring special circumstances of the sort you were talking about, that's generally something addressed by state authorities.
So we need to get this thing straight. We have some people complain we're federalizing too many crimes and then complain that we're striking down some that go too far. States should prosecute these cases locally and effectively, and should do that at guns, schools, and guns and that kind of thing. And in the Violence Against Women's Act, it was a Commerce Clause case where a woman was raped and then sued the people who assaulted her and raped her. She wanted to sue in federal court under the Violence Against Women's Act. And what the court held there was, as I read it, that it limited the court limited Congress's power to provide for civil damages, money damages. She could sue that rapist in state court, but not for money damages in federal court. Is that the holding of that case?
That's my understanding what the court held in the Morrison case, yes.
And I don't think it's an utterly extreme position. It certainly did not gut the Violence Against Women Act. It has so many more provisions than just that. If the action had been against a private business, could the damages have been rendered in that case?
I'm not sure I know the answer to that, Senator.
I'll take the follow-up on the Garrett case that several people have mentioned. Involved the University of Alabama in a lawsuit against the state institution claiming a violation of the Disabilities Act. The state defended on the grounds that you could sue the state of Alabama for back pay. You could sue the state of Alabama to get your job back. You could sue the state of Alabama and get an injunction against the state to not discriminate again in the future. But under the sovereign immunity doctrine that protects a state from lawsuits, you couldn't sue them for money damages. Now, Senator Cornyn is Attorney General of his state, and Attorney Generals like Attorney General, now Judge Bill Pryor, who defended Alabama, raised that defense. And I don't think it's a bogus defense. I think it's a legitimate concern. Judge, do you recall where the doctrine that's so famous in the law that the power to sue is the power to destroy? Do you remember where that came from in our legal history?
I remember tax opinions talking about it, but the power to tax being the power to destroy. But
I think the doctrine has been applied to the states, so we attorney generals are familiar with it under the sovereign immunity that the states have. If you're empowered to sue the state of Alabama in federal court, then you have virtually the power to destroy that state financially if there's no real limit on it. And so we've always provided, and the states have provided, a sovereign immunity that the states are only allowed themselves to be sued under certain circumstances, and you cannot just sue them unnecessarily. I know Senator Mark Pryor, our Democratic colleague, signed on the brief for the state of Alabama in the Garrett case, taking this position, and the Supreme Court ruled with it. So I also would note that it did not in any way destroy the Disabilities Act. It applied to only state employees only make up about 3.7% of the employees in the nation that might be covered by that. So I think I think there's been some healthy trends in reestablishing that there's some limit to the reach of the Commerce Clause. Would not you agree?
Well, the interesting thing in the court's most recent decision is the medical marijuana decision in the Raich case, and the court there looked at the Lopez and Morrison decisions and tried to put them in context and said, because the argument there was based on Lopez and Morrison, saying this is beyond Congress's power, and the court said those are only two of our cases, and they need to be put in the broad sweep of Commerce Clause precedents for over 200 years. Yes, there are two cases, and it had been, I think, 65, 70 years since the court had focused on limitation of under the Commerce Clause and concluded that it was beyond Congress's power. But the Raich case concluded this was within Congress's power. They said it's not as if Lopez and Morrison are junking all that came before. They just need to be considered in the broad context. And of course, there's decision after decision, going back to Gibbons against Ogden, one of Chief Justice John Marshall's early opinions about the scope of Congress's power and the recognition under the constitutional scheme that it is a broad grant of power, and the recognition that this body has the authority to determine when issues affecting interstate commerce merit a legislative response at the federal level. I think
you're just go on to another study, but I think you're correct. These are some difficult areas, and the court need to give a lot of attention to, but some recognition that there are limits to federal reach is, I think, legitimate for a court. Judge, are you aware of the salary that you'll be paid when you become, if you're so
in
fortunate?
A vague way, yes.
And I suppose you were when you were affirmed to the Court of Appeals.
Yes.
So you're not going to be back next week asking for a pay raise, are you?
Not next week, no.
Chief was always over here knocking on our door about pay raises, but you know we have a deficit in our country, and you are paid the same. I guess the chief may be paid more than senators, but for the most part, judges are paid what members of Congress are paid, and I frankly am dubious that we should give ourselves big pay raises when we can't balance the budget. I also chair the Courts Subcommittee, Courts and Administration, and as chief you have a serious responsibility with regard to managing and providing guidance to the Congress on the needs of the court system. I'm sure that you will do that with great skill and determination, but let me ask you, will you also seek to manage that court system, and I hesitate, but I will use the word bureaucracy at times, effectively and efficiently, and keep it a lean and effective management team, and maintain as tight a budget as you can maintain?
Well, if I am confirmed, Senator, the answer is yes. I'm aware that there is, for example, the administrative office, and they provide valuable services to judges around the country. As a consumer of their services for the past 2 years, I have certainly particular views about where I think they're effective and helpful to judges, and other areas where like any bureaucracy, where I think they can do better. It is an area where my first priority is going to be to listen, because I'm sure there are many considerations of which I'm not aware that are very important for the Chief Justice to take into account. And after listening, I'll try to make the best decisions I can about administering that system.
Well, there are a lot of problems. Judges are not happy with the General Services Administration, and sometimes GSA is not happy with the judges, and sometimes judges overreach and want to be treated awfully specially. And so I think you have a challenge there. I would look forward to working with you. If you'll help us make sure that your court system is lean and efficient and productive, we'll try to make sure that you have sufficient resources to do those jobs. One more thing, and I'd just like to inquire about, and that deals with stare decisis, the deference you give to a prior decision of the Supreme Court. And you've mentioned a number of factors, and I recognize those as valid and worthy of great consideration. But it almost strikes me that it's a bit circular. In other words, the court is creating a wall around its opinions to try to avoid seeing them overruled. Isn't it true that your first oath is to enforce the Constitution as God gives you the ability to understand it, and that sometimes decisions have to be reversed if they are contrary to a fair and just reading of the Constitution?
Yes, Senator. The oath we take is to uphold the Constitution and laws of the United States. That's true. And the way judges go about that is within a system of precedent and consistent with rules of stare decisis. No judge starts the day by opening a blank slate and said, what should the Constitution mean today? You operate within those systems of precedents. That's the best way that we judges have determined to interpret the Constitution and laws consistent with principles of stare decisis.
Judge, I'll just conclude with noting that I remember when the court in the Ninth Circuit ruled at striking down the Pledge of Allegiance. The then Majority Leader Tom Daschle came to the floor, as now Majority Leader Harry Reid did at the same afternoon, and they criticized the opinion and criticized the Ninth Circuit and expressed concern about activism in that circuit, which I have done often myself. But I responded that my concern was not so much with the circuit, but with the confusing number of opinions from the Supreme Court, and that I had no doubt that there was Supreme Court authority that would justify the Ninth Circuit rendering the ruling that they did. And I say that because we've just received word today that a judge in San Francisco has upheld, has ruled that the pledge's reference to one nation under God violates the Constitution and should be stricken down. So that case is going to be winding its way forward. I'm not going to ask you to comment on it because it will obviously come before you. But will you tell us whether or not you are concerned about the inconsistencies of these opinions, and will you work to try to establish a body of law in the Supreme Court that recognizes the free exercise rights of American citizens in regard to religion, and to avoid a state establishment of a religion?
Well, we've talked about this in the committee hearings on a couple of occasions, and I think everyone would agree that the religion jurisprudence under the First Amendment, the Establishment Clause and the Free Exercise Clause, it could be clearer. The Ten Commandments cases are the example right at hand. You have two decisions of the Supreme Court. Only one justice thinks both are right. That is an area in which I think the court can redouble its efforts to try to come to some consistency in its approach. Now, it obviously is an area that cases depend in a very significant way on the particular facts, and anytime that's the case, the differences may be explained by the facts. You do have the two provisions, as your question recognized, the Establishment Clause and the Free Exercise Clause. And as I've said before, I think that both of those are animated by the principle that the framers intended the rights of full citizenship to be available to all citizens without regard to their religious belief or lack of religious belief. That, I think, is the underlying principle, and hopefully the Court's precedents over the years will continue to give life to that ideal.
Well, thank you, Judge Roberts. You have, by your testimony, validated the high opinions that so many have of you. I'm confident you would make a great Chief Justice.
Senator.
Thank you.
Thank you, Senator Sessions. Senator Feingold.
Thank you, Mr. Chairman. Judge, let me start off by taking up a couple of new topics. In September 1985, when you were in the White House counsel's office, you recommended deleting the following line from the presidential briefing materials. Quote, "As far as our best scientists have been able to determine, the AIDS virus is not transmitted through casual or routine contact," unquote. You said at the time that the conclusion was in dispute. We now know, of course, that the line is completely accurate, but I would say we also knew that then. The Center for Disease Control guidelines issued the month before you wanted to delete that line said the following, quote, "Casual person-to-person contact, as would occur among school children, appears to pose no risk," unquote. Major news organizations had reported the CDC's conclusion. In fact, the CDC had said as early as 1982 that it was unlikely that HIV could be spread through casual contact.
I'm sorry, as early as when?
As 1982, that it was unlikely that HIV could be spread through casual contact. Why did you recommend that line be deleted?
Well, for the reason I gave in the memorandum. This was a statement by the President, and I just didn't want the President giving out medical advice if it was a subject of some uncertainty. I obviously was not a medical expert, and you said the CDC had issued a report a month before. Well, earlier in your commentary, I don't know what the 1982 issue was, but I just thought it's purely a matter of caution and prudence to have the President make a pronouncement on it. You have to remember this was at the very beginning of the AIDS coming into public consciousness, and I was just concerned that the President not be giving out medical statements if people weren't absolutely sure that it was correct. So
let me follow on that a little bit. It certainly was an early time and also a critical time. I'm wondering what you did to check or have someone check on these facts. I mean, you must have known that the issue was so important, the President was saying something like this, that it could have given a great reassurance to people all over the country, as well as helping children infected with the AIDS virus to live happier and more normal lives, to know that this was the medical conclusion. So I'm just wondering why you wouldn't have checked it out.
I mean, the flip side of that, Senator, of course, is if it turned out to be wrong, it could have been disastrous to have the President announcing, because the President wasn't a medical expert either. And I'm sure my suggestion would have caused the people drafting the President's speech to go back, and if they thought they were convinced and they were sure, then that's what would have gone in there. It was just a question of concern. I wanted to make sure that they were 100% confident that what the President was going to be saying about a medical issue was they had complete confidence in it. I don't know actually whether they took it out or left it in, but at least it caused them to focus.
I don't want to belabor it, but I think that was a great opportunity for presidential leadership and reassurance, and would just respectfully disagree with your judgment there.
Well, my judgment, just so I could finally,
fair enough,
it wasn't my medical judgment. The impact of my suggestion was obviously to cause the people who wanted that in there to go back and make sure they were sure that they wanted the President of the United States issuing a medical statement.
I think it was pretty certain at that time what the medical view was, as indicated by the medical community of our own government, but I'll leave it at that. Do you believe that the Congress has the power under the Constitution to prohibit discrimination against gays and lesbians in employment?
I don't know if that's an issue that's going to come before the courts. I don't know if Congress has taken that step yet. And until it does, I think that's an issue that I have to maintain some silence on. I think, personally, I believe that everybody should be treated with dignity in this area and respect. The legal question of Congress's authority to address that, though, is one that could come before the courts, and so I shouldn't.
Can you imagine an argument that would be contrary to that view?
I don't know what arguments people would make. I just know that I shouldn't be expressing an opinion on issues that could come before the court.
Let's go to something else then. I'd like to hear your views about the Second Amendment, the right to bear arms. This is an amendment where there is a real shortage of jurisprudence. You mentioned the Third Amendment where there's even less jurisprudence, but the Second Amendment's close. So I think you can maybe help us understand your approach to interpreting the Constitution by saying a bit about it. The Second Amendment raises interesting questions about a constitutional interpretation. I read the Second Amendment as providing an individual right to keep and bear arms as opposed to only a collective right. Individual Americans have a constitutional right to own and use guns, and there are a number of actions that legislatures should not take, in my view, to restrict gun ownership. The modern Supreme Court has only heard one case interpreting the Second Amendment. That case is U.S. versus Miller. It was heard in 1939. And the court indicated that it saw the right to bear arms as a collective right. In a second case, in U.S. versus Emerson, the court denied cert and let stand a lower court opinion that upheld a statute banning gun possession by individuals subject to a restraining order against a Second Amendment challenge. The appeals court viewed the right to bear arms as an individual right. The Supreme Court declined to review the appeals court decision. So what is your view of the Second Amendment? Do you support one of the other of the views of what was intended by that amendment?
Yeah. Well, I mean, you're quite right that there is a dispute among the circuit courts. It's really a conflict among the circuits. The Fifth Circuit, I think it was in the Emerson case, if I'm remembering it correctly, agreed that with what I understand to be your view, that this protects an individual right. But they went on to say that the right was not infringed in that case. They upheld the regulation there. The Ninth Circuit has taken a different view. I don't remember the name of the case now, but a very recent case from the Ninth Circuit has taken the opposite view, that it protects only a collective right, as they said. In other words, it's only the right of a militia to possess arms and not an individual right. Particularly since you have this conflict, cert was denied in the Emerson case. I'm not sure it's been sought in the other one or will be. That's the sort of issue that's likely to come before the Supreme Court when you have conflicting views. I know the Miller case sidestepped that issue. An argument was made back in 1939 that this provides only a collective right, and the court didn't address that. They said instead that the firearm at issue there, I think it was a sawed-off shotgun, is not the type of weapon protected under the militia aspect of the Second Amendment. So people try to read the tea leaves about Miller and which would come out on this issue, but that's still very much an open issue.
Well, understanding that a case could come before you, I'm wondering if you would anticipate that in such a case that a serious question would be which interpretation is correct.
Well, anytime you have two different courts of appeals taking opposite positions, I think you have to regard that as a serious question. That's not expressing a view one way or the other. It's just saying, I know the Ninth Circuit thinks it's only a collective right. I know the Fifth Circuit thinks it's an individual right. And I know the job of the Supreme Court is to resolve circuit conflicts. So I do think that issue is one that's likely to come before the court.
I'd like to revisit the Hamdi issue. I asked you which of the four opinions in the case of Hamdi v. Rumsfeld best approximates your view on the executive's power to designate enemy combatants, and you refused to answer that question because the issue might return to the court. But I want to press you a bit on that. In Hamdi, there were four different opinions, and by the way, I checked it because you mentioned Youngstown, and all four opinions cited the Youngstown Sheet and Tube versus Sawyer case. Both Justice Thomas's dissent and Justice Ginsburg and Souter concurring cited Justice Jackson's opinion in the Youngstown case, and they came to completely different conclusions. So your answer that you would apply that principle doesn't help me very much in understanding your view of this. We know where all 8 other members of the court stand on these opinions. In their opinions, they either wrote or joined one of them, yet all 8 of them will hear the next case that raises similar issues. No one is suggesting that their independence or impartiality in the next case has been compromised. Now, Mr. Hamdi, of course, has left the country, so the precise facts of his case will never return to the court. Of course, if a member of the court expressed a view outside of the court on a specific case that was headed the court, that might be cause for recusal, as Justice Scalia recognized when he recused himself from the Pledge of Allegiance case a few terms ago after discussing it in a speech. But obviously, Justice Scalia can participate in the next case involving the questions at issue in Hamdi, even though we know exactly what he thinks about that decision. So I guess I want to know, why are you different I'm not asking for a commitment on a particular case. I recognize that your views might change once you're on the court and hear the arguments and discuss the issue with your colleagues, but why shouldn't the public have some idea of where you stand today on these crucial questions concerning the power of the government to jail them without charge or access to counsel in a time of war? They know a great deal about how each of the other justices approach these issues. Why is your situation different?
Well, because each of the other 8 justices came to their views in those cases through the judicial process. They confronted that issue with an open mind. They read the briefs presented by the arguments, by the parties and the arguments the parties presented. They researched the precedents as a judge. They heard the argument in the case. They sat in the conference room, just the 9 of them, on the court, and debated the issues and came to their conclusions as part of the judicial process. You're now asking me for my opinion outside of that process, not after hearing the arguments, not after reading the briefs, not after participating with the other judges as part of the collegial process, not after sitting in the conference room and discussing with them their views, being open to their considered views of the case, not after going through the process of writing an opinion, which I have found from personal experience and from observation often leads to a change in views, the process of the opinion writing. You can't, the opinion turns out it doesn't write. You have to change the result. The process, the discipline of writing helps lead you to the right result. You're asking me for, you're asking me for my views, just, you know, right here without going through any of that process.
What would be the harm, Judge, if we got your views at this point and then that process caused you to come to a different conclusion, as it appropriately should? What would be the harm?
Well, the harm would be affecting the appearance of impartiality in the administration of justice. The people who would be arguing in that future case should not look at me and say, well, there's somebody who under oath testified that I should lose this case, because this is his view that he testified to. They're entitled to have someone consider their case through the whole process I've just described, not testifying under oath in response to a question at a confirmation hearing. I think that is the difference between the views expressed in the prior precedent by other justices in the judicial process and why, as has been the view of all of those justices, every one of those justices who participated in that case took the same view with respect to questions concerning cases that might come before them as I'm taking here.
I understand your view. I think it's narrow. I mean, I had the experience of having one of my bills go before the Supreme Court, and I know I didn't have, as we say in Wisconsin, a snowball's chance with a couple of the justices because of how they had ruled previously, but I didn't think that made the process in any way tainted. I knew that they simply weren't going to agree with this statute, but I recognize your limitations here. Let me ask you about something else, the Hamdan matter. Yesterday you refused to answer any questions regarding your conduct in the Hamdan versus Rumsfeld case. But today you answered questions from Senator Coburn regarding this matter. So I want to follow up in order to make sure the record is complete. You interviewed with the Attorney General of the United States concerning a possible opening on the Supreme Court on April 1, 2005. Is that correct?
Yes. The specifics of the details I've discussed in the response to the committee's questionnaire.
And that was 6 days before the oral argument in the Hamdan case, isn't that right?
I don't remember the exact date of it. I know it was shortly before that, yeah.
You had further interviews on May 3rd concerning a possible appointment to the court with numerous White House officials, including Karl Rove, the Vice President, and the White House counsel before the decision in the Hamdan case was released. Isn't that correct?
The decision was June 15th.
The question here is just, did you have further interviews on May 3rd concerning a possible appointment to the
May
court?
May 3rd, yes. Well, whatever was, I don't remember the exact dates, but whatever
you
was
had interviews with those individuals.
In the Senate
record seems to indicate it was on May 3rd. You met again with Ms. Myers, the White House counsel, on May 23rd. Isn't that right?
I'm relying on the, if that's what I said in the questionnaire, yes. I don't have an independent recollection.
You have no reason to doubt that those facts are correct. You never informed counsel in this case of these meetings, did you?
I did not, no.
Mr. Gonzalez's advice to the President concerning the Geneva Conventions was an issue in the case. Isn't that right?
I don't want to discuss anything about what's at issue in the case. The case is still pending and pending before the Supreme Court.
Well, how about this one? President Bush was named a defendant in the case, right?
Yes. In his official capacity.
The Hamdan decision was released on July 15th. Is it your testimony that no work on that decision took place after July 1?
No, I didn't. That was not my testimony. The opinions in the D.C. Circuit.
Oh, using your testimony now that no work on that decision took place after July 1.
Opinions in the D.C. Circuit are complete and circulated to the panel a week before they're released. That was the conclusion of when work was complete. And again, I wasn't the author of the opinion. It would have been a week before it was released.
Did you read over the opinion of the concurrence after July 1? Was there any editing that took place after that date?
I don't recall, Senator. And
well, when was the issue of whether you should recuse yourselves from this case? When did that first come to your attention?
I saw and was made aware of an article. I think it was an article. I don't remember when that took place. Whenever the article was published, and then I understand there was legal opinions on the other side were requested by, I believe, the chairman, and I know that those were published.
You don't recall
well.
when this matter first came up, and would think would be something you'd remember is when somebody suggested you should have recused yourself.
I don't remember the date of the.
How about the approximate time?
It was. I think it was sometime in July or.
Mr. Chairman. So the record will be complete. I'd like to submit the article from Slate magazine by Professors Gillers, Luban, and Lubet in a letter sent to you responding to Professor Rotunda's criticism of their position. And I also want to submit an article by these 3 law professors that was published in the Los Angeles Times on this topic. I don't want to take any more time on this, but I think these professors...
Without objection, they will be made a part of the record.
Thank you, Mr. Chairman. I think these professors very convincingly answer Professor Rotunda's views and point out that his analysis of the case law is not particularly persuasive. And I would urge any of my colleagues who really want to understand the issue with Judge Roberts' participation in the case, rather than just dismissing it because it's inconvenient, that they take a look at it and actually see what the issues were here. But I do appreciate your answer to those questions. I will only be able to get to some of my questions on the next subject, and hopefully the next round can continue. But Judge Roberts, as Senator Leahy mentioned earlier, when you came before the committee a couple of years ago, we discussed the fact that more than 100 people on death row have been exonerated and released. And in fact, I believe the number is now 121 people who we know were sentenced to die for crimes they did not commit. I want to follow up on the work that Senators Durbin and Leahy have done in discussing with you the Herrera case. I do differ with your characterization of the case. The Solicitor General brief that you signed presented the issue as whether the Constitution, quote, requires that a prisoner have the right to seek judicial review of a claim of newly discovered evidence, unquote. That is, the question was not how strong the evidence of innocence must be, as you seem to be suggesting earlier, but whether the Constitution requires that there be some avenue presenting evidence of innocence in federal court. Your brief argued that it does not. Now, that brief also, as you know, contained a footnote that I'm going to ask you to comment on. It said, quote, there is no reason to fear that there is a significant risk that an innocent person will be executed under the procedures that the states have in place. The direct review and collateral procedures that the federal government and the states have in place are more than ample to separate the guilty from the innocent. And yesterday you talked about the possible effect of DNA evidence on the legal framework in this type of case. In light of the many cases of innocent people ending up on death row that have come to light in the past decade, and aside from what was the ultimate issue at stake in that case, do you still agree with your statement from the government's Herrera brief?
Well, that was the administration position at the time. It was one that the Supreme Court agreed with. 6-3, I think, was the ruling. I know Justice O'Connor was in the majority. The issue, and again, there was obviously argument at the time about what the issue really was in Herrera, and I thought it was quite inaccurate to view it as a case involving the question of whether actual innocence could be presented, because it was a claim of newly discovered evidence, and it was a claim that somebody who just died was actually the murderer. At the end of exhaustive appeals through the state system, exhaustive collateral review through the state system, exhaustive collateral review for the federal system, is there an obligation to decide at that point that a new claim that somebody else committed the crime?
I'm just running out of time. I'm wondering if you just still stand by the statement, if you could just say yes or no. Or
well, that was the administration position that was presented.
Let me cut to the quick one. I'd like to know whether you think there's a risk that innocent people may be sentenced to death in today's criminal justice system. And I must say, Judge, Supreme Court justices do have the power of life and death in these matters.
Senator, I think there is always a risk in any enterprise that is a human enterprise like the legal system. Obviously, the objective of the provision of the rights to a criminal defendant and trial, the provision of collateral review at the state level, the provision of collateral review at the federal level, the availability of, as you suggested, clemency, all of that is designed to ensure that the risk is as low as possible. There are issues that are going to be presented about the availability of DNA evidence, which may or may not help reduce the risk even further. There's always a risk, and obviously when you're dealing with something like capital punishment, the risk is something that has to be taken extremely seriously at every stage of the process. As we talked about more than 2 years ago at the prior hearing, I think the most effective way of minimizing that risk is to ensure that people facing that sanction have the best counsel available at every stage. As you know from looking at this problem, the issue that comes up are questions that weren't raised, that should have been raised if the person had a more capable lawyer, avenues that weren't pursued that should have been pursued if that lawyer had the resources. And that's where I think the risk of wrongful conviction is going to be most effectively addressed, ensuring the availability of competent counsel at every stage of the proceeding.
Thank you, Judge.
Thank you, Senator.
Thank you, Senator Feingold. Senator Graham.
Thank you, Mr. Chairman. Judge Roberts, your intellectual stamina impresses me because you can't see this on television. It must be 150 degrees in here. I just don't know how you're doing it, but I'm tremendously impressed. Mr. Chairman, I would like permission to introduce into the record some law professor's opinion that being interviewed for the Supreme Court vacancy when Judge Roberts was interviewed did not require him to recuse himself, and I'll do that
without objection. They will be made a part of the record.
But let's think about that in kind of political terms, and I know that's not really your job. If we took this to its logical conclusion, say I was president, I don't think that's going to happen, so you don't need to be overly worried about it, but you could pick someone to be Chief Justice from the court, people sitting on the court, is that correct?
Yes.
So if you had a judge you didn't particularly like, the best thing you could do is go talk to them about the job and they couldn't decide anything. Would that be the logical conclusion of this?
I think that would be the logical conclusion of some of the
Well, I'll
views.
remember that if I'm president. But now, on my record now, I don't think I should have the right to do that. That's part of the process. Some big themes here. Were you proud to work for Ronald Reagan?
Very much, Senator, yes.
During your time of working with Ronald Reagan, were you ever asked to take a legal position that you thought was unethical or not solid?
No, Senator, I was not.
We've talked about the Voting Rights Act. The proportionality test in the Reagan administration's view was changing the Voting Rights Act to create its own harm. Is that correct?
The concern that the Attorney General had and the President was that changing Section 2 to the so-called effects test would cause courts to adopt a proportionality requirement, that if elected representatives were not elected in proportion to the racial composition in a particular jurisdiction, that there would be a violation shown that would have to be redressed.
Do you think it would be fair to try to suggest that because you supported that position that you're somehow racially insensitive?
No, Senator, and I would resist the suggestion that I'm racially insensitive. I know why the phrase equal justice under law is carved in marble above the Supreme Court entrance. It is because of the fundamental commitment of the rule of law to ensure equal justice for all people without regard to the race or ethnic background or gender. The courts are a place where people need to be able to go to secure a determination of their rights under the law in a totally unbiased way. That's a commitment all judges make when they take a judicial oath.
Knowing this will not end this line of inquiry, but at least trying to put my stamp on what I think we found from this long discussion. Basically, the Supreme Court decided in Section 2 that the intent test was constitutionally sound. Is that correct?
That's what it was, its determination in Mobile against Bolden.
And Senator Kennedy disagreed because he wanted a different test. And I respect him. He is one of the great First, he's not part of the Reagan Revolution. I think we all can agree with that, so I don't expect him to buy into it. But I respect him greatly for his passion about his causes. He took it upon himself to try to change the Supreme Court ruling, to go away from the intent test to the effects test. And he was able to reach a political compromise with the administration. And I just want that to be part of the record. That to say that Ronald Reagan or Judge Roberts, by embracing a concept approved by the court, equates to that administration or this person being insensitive to people of color in this country, I think is very unfair and off base. You said something yesterday that was very compelling to me. I asked you, could you express or articulate what you thought might be one of the big threats to the rule of law? And I believe you said judges overstepping their boundaries, getting into the land of making the law, putting their social stamp on a cause rather than interpreting the law, because that could, over time, in the eyes of the public, undermine the confidence in the court. Is that a correct summary?
Yes, Senator.
Well, we have before us today, Judge Roberts, a legal opinion just issued, hot off the presses, that says the Establishment Clause of the Constitution apparently is violated if an American recites the Pledge of Allegiance. You will be on the court, I hope, and you will use your best judgment on how to reconcile the Ninth Circuit opinion. And I'm not asking you to tell us how you might rule. I'm making a personal observation that this is an example, in my opinion, of where judges do not protect us from having the government impose religion upon us, but declare war on all things religious. And that is my personal view and opinion. That's why most Americans sometimes are dumbfounded about what's going on in the name of religion. No American wants the government to tell them how to worship, where to worship, or if to worship. But when we exercise our right to worship, it bothers me greatly that judges who are unelected confuse the concept between establishment and free exercise. And I will move on. I think it is one of the cases that is undermining the confidence in the judiciary, and I'm glad you're sensitive to that. The war on terror. In my past legal life, I've spent most of my legal career associated with the military, and I'm proud to be a military lawyer. I'm the only reservist in the Senate. I sit as an Air Force Court of Criminal Appeals judge. I handle the easy cases because I don't have a whole lot of time, and I help where I can. But I understand, I think, very well what it means to abide by the judicial canons of ethics, not to tip your hand, not to compromise yourself, to get promoted or to get put on the court. Promoted in the military or to get put on the court, trying to please your boss, trying to please a senator. And my respect for you has gone up because you're unwilling to compromise your ethics. And I hope the Senate will understand that in the past, other people were not required to do so. Are you familiar with the Geneva Convention?
Yes, Senator.
Do you believe that the Geneva Convention as a body of law, that it has been good for America to be part of that convention?
I do, yes.
Why?
Well, my understanding in general is it's an effort to bring civilized standards to conduct of war, a generally uncivilized enterprise throughout history, an effort to bring some protection and regularity to prisoners of war in particular, and I think that's a very important international effort.
As Senator Kyl said, this will be the only time we'll actually get to talk. And I don't want to compromise your role as a judge, but I do want you to help me express some concepts here that America needs to be more understanding of. And I want to work with my Democratic friends to see if we can find some way to deal with this. We're dealing with an enemy that is not covered by the Geneva Convention. Al-Qaeda, by their very structure and nature, are not signatories to the Geneva Convention and are not covered under its dictates. An enemy combatant, are you familiar with that term in the law?
Yes, Senator, I am.
What would an enemy combatant be under American jurisprudence? Who would they be?
Well, I really have to
Fair enough.
think
Fair enough.
those cases are both pending. The ones that I've decided are pending before the Supreme Court, and those issues are likely to come before.
Fair enough. The Geneva Convention doesn't cover al-Qaeda, but our president has said that anyone in our charge, terrorist or not, will be treated humanely. I applaud the president because in fighting the war on terror, we need not become our enemy. Our strength as a nation is believing in the rule of law, even for the worst of those that we may encounter. I admire Mr. Adams for representing the redcoats. I cannot imagine how tough that must have been. But his willingness to take on the unpopular cause in the name of the rule of law has made it stronger. When the president said that we will treat everyone humanely, even the worst of the worst, I think he's brought out the best in who we are. But we're in a war, Judge Roberts, where the Geneva Convention doesn't apply, and we have before the courts a line of cases dealing with the dilemma this country faces. When you capture an enemy combatant, non-citizen foreign terrorist, there's three things I think we must do. We must aggressively interrogate them without changing who we are. We must have the ability to keep them off the battlefield for a long period of time to protect our nation. And we must have a system to hold them accountable for some of the most horrible crimes imaginable. Justice Jackson was one of your favorite justices, is that correct?
I think that's a fair description, yes.
He has indicated in the Youngstown Steel case that the presidency or the executive branch is at its strongest when it has concurrence with the legislative branch. Is that a fair summary of what he said?
Yes, he divided up the area basically into three parts, and considering the executive's authority, and said when it has the support of Congress, it's at its greatest, and obviously when it's in opposition to Congress, it's at its lowest ebb, as he put it. And he described a middle area in which it was sometimes difficult to tell whether Congress was supporting the action or not.
This is me speaking, not you. Congress is AWOL, ladies and gentlemen, in the war on terror when it comes to detention, interrogation, and prosecution of enemy non-citizen combatants. Justice Scalia has written eloquently that Congress has the power to get involved in these issues, and Congress is silent. What is the case? Is it the Rasul case where the Supreme Court in a 5-4 decision has given habeas corpus rights to non-citizen foreign terrorists?
I think that's correct, Senator, yes.
That is an amazing departure from what we've been as a nation for 200 years. I have been to Guantanamo Bay twice. The people running the prison tell me that 185 of the detainees have lawyers in federal court. Justice Scalia says we've set up a situation where 94 different jurisdictions can hear habeas cases involving non-citizen foreign terrorists. The people running the jail says this process is undermining our ability to get good information. An habeas corpus petition hearing, would it allow a defense attorney to call a military commander in to answer for how this person was captured?
I don't know, Senator, and I hesitate to opine on that without knowing.
Well, the truth is that we've set up a situation where our military leaders and our military commanders and soldiers in the field can be called from all over the world, all over the country, to answer for why such person is detained. We had a conversation in our office, my office.
I haven't agreed to a third round yet.
You said something to the effect, as Justice Scalia said in his dissenting opinion, that this would be an area where the courts would welcome some congressional involvement. And right now we have the executive branch carrying the load totally by themselves. We've got several cases before the court dealing with detention policy, interrogation policy, and prosecution policy. Do you believe that this is an area, if the Congress acted, as Justice Jackson said, that it would strengthen the hand of the executive in a legal situation?
My observation during our meeting, Senator, was not an expression of legal determination, and it doesn't necessarily mean a view that Congress's action or involvement would be determinative or would even be within the scope of legal authority, depending on what the issue and the arguments were. I do know that when you are in the middle area, where it's difficult to determine whether Congress is supporting the President's action or is opposed to the President's action, that the Court often has to try to read the tea leaves of related legislation. If you look at the Dames and Moore decision coming out of the Iranian hostage crisis, what the Court did in that case, applying the middle tier, was look at a vast array of legislation, and it was a very difficult enterprise to try to figure out what Congress's view was. My point was simply that if we know what Congress's view was, it might make it easier to apply it in a particular case, and you wouldn't have to go through that process of trying to determine what position Congress was in if that turned out to be pertinent under the particular legal challenge.
Thank you. Justice Scalia said in a very direct way, the courts are ill-equipped to deal with these issues. In the Youngstown Steel case, Justice Jackson says, when the President acts pursuant to an express or implied authorization of Congress, his authority is at the maximum, for it includes all that he possesses in his own right, plus all that Congress can delegate. A seizure executed by the President pursuant to an act of Congress would be supported by the strongest of presumptions and the widest latitude of judicial interpretation, and the burden of persuasion would rest heavily upon any who may attack. Do you agree with that?
That was read from the Jackson opinion. I do. I agree with the basic proposition that the President's authority is at its greatest when he has the support of Congress.
To my colleagues, I think it is imperative for this body to get involved in the war on terror when it comes to detaining, interrogating, and prosecuting enemy combatants who are not citizens. It is important that all three branches of government, in my opinion, feel comfortable with the policies of this nation, that will be stronger if the judicial branch, the legislative branch, and the executive branch are working together to come up with policies that will allow for aggressive interrogation, appropriate detention, and serious prosecution in a way that's within the values of our nation. So that is why I will be introducing legislation on all those topics, and I will not ask you any further what you may or may not do about the legislation if it ever gets to the floor of the Senate and passed. The Kelo case. Of all the things that have been decided, and I haven't been to my office since the recent case about the pledge, so it may have trumped it, I have gotten more phone calls about the Kelo case than anything the Supreme Court has done lately. And for those who may be tuning in, the Kelo case basically said that the government can take your property, give it to someone else, another private person, because it could be used at a higher and best use and it might generate more taxes. I'm not going to ask you to tell me how you decide the Kelo case, but I just want you to know, as Senator Kyle indicated, this is the only time you can hear from us, that my phone is ringing off the hook, and that every legislature that I know of is going into session as quickly as they can to correct that. So I want to leave with you, and when you meet your new colleagues, please let them know that some of the things they do that we watch, and that the courts are able to do their job because the public defers to the court and respects the court. But there is a limit. The office of Chief Justice of the United States is different as you're the first among equals. What do you believe as Chief Justice you can bring to the table that you could not as just a normal member of the court?
Well, if I am confirmed, I think one of the things that a Chief Justice should have as a top priority is to try to bring about a greater degree of coherence and consensus in the opinions of the court. I know that was a priority of the last Chief Justice. I actually believe that is something that should be a matter of concern for all of the justices. But as the Chief, with the responsibility for assigning opinions, I think he has a greater scope for authority to exercise in that area, and perhaps over time can develop greater persuasive authority to make the point. And again, coming from the Chief, it may be a point that other justices would receive, be more receptive to than they might coming from one of their colleagues, that we're not benefited by having 6 different opinions in a case, that we do need to take a step and think whether or not we really do feel strongly about a point in which a justice is writing a separate concurrence to which only he or she is joining, or whether the majority opinion could be revised in a way that wouldn't affect anyone's commitment or to the judicial oath to decide the cases as they see fit, but would allow more justices to join the majority. So the court speaks as a court. That is something that the priority should be, to speak as a court.
So your goal as Chief Justice is where you can and as often as you can to find consensus and unite the court. Is that true?
I think the court should be as united behind an opinion of the court as it possibly can. Now, obviously, in many cases, it's not going to be possible.
I applaud you because we're a divided nation. And the more united we can become at any level of government, the stronger we'll be. So I applaud you with that attitude, for that attitude.
Thank you very much, Senator Graham. Senator Schumer.
Thank you, Mr. Chairman. And Judge Roberts, it's nice to talk to you so early in the day. Yesterday, you stated that you, quote, agree with the Griswold Court's conclusion that marital privacy extends to contraception and the availability of that, unquote. And you noted that the Court's later decisions have based the constitutional right to privacy on the liberty component of the Due Process Clause of the 14th Amendment. Now, Justice Thomas, at his confirmation hearing, answered in a way very similar to the way you did. During his confirmation hearing, here's what he said, quote, I believe the approach that Justice Harlan took in Griswold in determining or assessing the right to privacy was an appropriate way to go, unquote. Now, we all know that Justice Harlan's approach located the right to privacy in the liberty interest of the Due Process Clause of the 14th Amendment. And Justice Thomas also said at his confirmation hearings along the same lines that he agreed with the court decision in Eisenstadt v. Baird, where the court held that single people have the same right to privacy as married people on the issue of procreation. However, since he's been confirmed to the court, Justice Thomas has not applied the right to privacy to keep protections. For instance, in Lawrence in 2003, he declared that there is no general right to privacy in the Constitution. Now, yesterday you said that, quote, liberty is not limited to freedom from physical restraint. It does cover areas, as you said, such as privacy. It's not only protected in procedural terms, but protected substantively as well. You said that you agreed that there's a right to, quote, there's a right to privacy to be found in the Liberty Clause of the 14th Amendment. So that seems directly to contradict Justice Thomas's view once he got on the court, as I outlined in Lawrence. I assume that you disagree with Justice Thomas's view that there is no general right to privacy as he stated in Lawrence.
Well, I think that question depends obviously on the modifier and what you mean by general. I noted in going over the nomination hearings of Justice Breyer, he also said that the privacy interest is within the protected as part of the liberty protected by the Due Process Clause. I think that is the general approach. Now, let's
talk about Justice Thomas. He said there's no general right of privacy. You seemed to say yesterday, you didn't seem to say, you said that there was a right to privacy. Let's forget that Justice Thomas said it. You would disagree that there is no general right to privacy in the Constitution?
I wouldn't use the phrase general right, because I don't know what that means. I don't know if by saying general they're trying to describe the particular scope to the right to privacy or not. I think there is a right to privacy protected as part of the liberty guaranteed in the Due Process Clause.
A substantive right to privacy.
It's protected substantively, yes.
Your reading of Justice Thomas's case in Lawrence that he does not believe in that?
No, I think his statement obviously focuses on general, and his conclusion in that case was that the right to privacy protected under the Due Process Clause that you noted he acknowledged at his hearings did not extend to include the activity at issue in Lawrence.
Well, this is obviously very important because Justice Thomas seemed to be more full in his view of privacy at his confirmation hearing than later when he was on the court, at least if you read his decisions. And you are not willing to say that your view is different than the view Justice Thomas stated in Lawrence.
I'm not willing to state a particular view on the Lawrence decision, and that's consistent with the approach that I've taken.
And then let me ask you a broader question. Do you disagree with Justice Thomas's interpretation of the right to privacy in any decided case?
Well, Senator, I'm not going to comment on whether I think particular cases were correctly decided or not in
I didn't
areas.
ask that.
Well, I don't know which cases you're talking about, but
any one you want.
Well, that would be commenting on whether that decision was correctly decided or not. If I'm agreeing or disagreeing with one of the justices' views in that case, that would be commenting on whether that view was correct or not. If it was in a dissent, it would be disagreeing. If it was in the majority, it would be agreeing. And because those are in areas that could come before the court, like every other nominee to come before this committee who's on the court today, I think it's inappropriate to comment on the correctness or incorrectness of those decisions in areas that could come before the court.
So you don't have to answer this. It's obvious you will not state where you disagree with Justice Thomas, and it could well be that what he said at his hearing and you said at your hearing might lead you to rule in the same way on privacy?
Well, again, my view on privacy is, as I've expressed, that there is a right to privacy protected as part of the liberty under the Due Process Clause.
Would you say there's a general right to privacy?
I don't know what general means.
Substantive right to privacy.
Well, substantive, yes. I have said that the protection extends to substantive protection. But when you say general, I don't know what that means. I don't know if that means it applies.
Didn't Justice Thomas disagree with the substantive right to privacy in Lawrence?
His conclusion was that the liberty protected by the Due Process Clause did not extend to that right, yes.
Thank you. So it would seem to me you disagree with him. I think you just said it without saying it.
No, Senator, you're asking me whether the right to privacy protected under the Liberty Clause extends to a particular right, the right at issue in Lawrence.
Well, I think what I'm asking you, is there a substantive right to privacy? I didn't apply it to a particular case.
I have said there is a substantive right to privacy. Now,
and in Lawrence, Justice Thomas seemed to say there is no substantive right to privacy.
No, as I understand it, and again, his testimony as a nominee was that there was. What he said is the quote you read in Lawrence said there's no general right to privacy. Now, I don't know. But
his holding was that there was no substantive right to privacy under the Liberty Clause. Wasn't it? Wasn't that the whole thrust of his argument?
No, I think, Senator, that his conclusion in Lawrence was that whatever right there was, it did not extend to the activity that was at issue in Lawrence.
Bottom line is you're unwilling to differentiate yourself from Justice Thomas's view in Lawrence.
Well, it's consistent with the approach I've taken that I don't think it's appropriate to protect, as necessary to protect the independence and integrity of the court, to comment on whether that decision was correctly decided or not. And that is consistent with the approach that every member of the court has taken.
I just didn't ask you that. I asked you if you would. I asked you if you disagreed with his particular holding. But let me ask you a few other questions here, because I think you're cutting back a little on what you said yesterday, at least if you look at the whole picture here and your unwillingness to disagree with Justice Thomas. But let me ask you this about judges in general. You sit on a court, correct? Okay. And sometimes you dissent. And that's routine, not just for you, but for every judge.
It's rare on our court, I'm happy to say.
Yes, it is. That is true. I've noticed that. But it happens in courts all the time. Okay. And in doing so, the dissenting judge is criticizing the majority opinion, right? Disagreeing with it. And I take it this happens on the Supreme Court quite often. And in fact, there aren't that many unanimous Supreme Court cases on major cases these days.
Well, actually, at one point, the statistics always showed that more cases were unanimous than anything else.
But there are a lot of dissenting judgments. And every justice on the Supreme Court has dissented in many cases, meaning they disagreed with the opinion of the court, right? And nothing is wrong with that. There's nothing improper, nothing unethical. Okay. Let's go to commentators. Non-judges are free to criticize and disagree with Supreme Court cases, correct?
Yes.
In speeches, law review articles. This is a healthy process, wouldn't you say?
I agree with that, yes.
And you did this occasionally when you were in private practice?
Yes.
Okay. Nothing unseemly about that?
No.
Okay. And how about lawyers representing clients? Lawyers representing clients criticize cases in legal briefs all the time. That's what they do for a living.
Yes.
And that's part of being a good lawyer. And you've signed your name to briefs explicitly criticizing and disagreeing with Supreme Court decisions.
On occasion, yes.
In Rust v. Sullivan, for example, your brief said that, quote, Roe was wrongly decided and should be overturned, unquote, right?
Yes.
Okay. But in this hearing room, you don't want to criticize or disagree with any decided cases. That seems strange to me. It seems strange, I think, to the American people, that you can't talk about decided cases, past cases, not future cases, when you've been nominated to the most important job in the federal judiciary. You could do it when you worked in the White House. You could do it when you worked in the Justice Department. You could do it when you worked in private practice. You could do it when you gave speeches and lectures. As a sitting judge, you've done it until very recently. You could probably do it before you just walked into this hearing room, and if you're confirmed, you may be doing it for 30 years on the Supreme Court. But the only place and time that you cannot criticize any cases of the Supreme Court is in this hearing room, when it is more important than at any other time that the American people and we, the senators, understand your views. Why this room should be some kind of cone of silence is beyond me. The door outside this room doesn't say, check your views at the door. So your failure to answer questions is confounding me. You've done it in instance after instance after instance after instance. What is the difference between giving your views here in this hearing room and what judges do every day, what professors do every day, what lawyers do every day? In each case, they have to state their opinion. They have to do it as part of their job, if you will, writing a brief, rendering an opinion, writing an article. In each case, they're stating their views, which might bias them. You've done it. Yet, only here, you can't state your views. If the argument, and by the way, there's a very good countervailing reason that you should state your views, because, as the Founding Fathers so constructed, this is the one time you go before an elected body, before a lifetime appointment. And it seems to me this is something of an argument of convenience. Senator Specter said it well. He said you'll answer as many questions as you have to get confirmed. That may be the actual fact, but it's not the right thing to do, in my judgment. And so please tell us, why is the bias? Why is the fact that you've already stated an opinion any different when you sit in this room in terms of jeopardizing your future as a judge than it is when you're doing all these other things that you've done? And let me just remind you, I'm going to give you a chance to answer this, but I think it's bothering a lot of people in this room and out of this room. Justice Ginsburg, people who have sat in your very chair, just about every single justice, with one or two exceptions, has given their opinions of existing cases. Justice Ginsburg said on Roe v. Wade, "My view is that if Roe had been less sweeping, people would have accepted it more readily." Do you think she was unable to keep an open mind in cases implicating Roe? Do you? Do you think she was unable to keep an open mind? Just answer me about her, not about what
Senator, I'll explain why she expressed her views on that particular issue. It was an explanation that she gave at the time, that she had written extensively on that subject, and she thought that her writings were fair game for discussion. She took a different view.
Excuse me, because I want to, she would be expressing an opinion which might yield bias whether she wrote before or not. She did it over and over again. She praised Learned Hand's First Amendment decision in Mass's publication. I don't think she was biased to keep her mind open on courts in that line, as Joe Biden said in Moore versus City of Cleveland. She candidly, and I don't think she had writings on that one, she expressed the opinion, the opinion has difficulties, and other justices have done it. Justice Breyer talked about U.S. v. Booker. Justice Powell about Miranda. Justice Souter about Miranda. Didn't bias him in the Dickerson case. Not all of these people had previously written. You can make a distinction to every single example I give. You can say, well, she wrote on that one. But when you add it all up, you are being less forthcoming. I know you're doing what you feel is right, but you're being less forthcoming with this committee than just about any other person who has come before us. You are so bright, and you know so much. But there's another aspect to this, which is letting us know what you think. And you've set up your own little construct. It's not really the Ginsburg precedent, or it isn't Canon 5, which you cited repeatedly at your Court of Appeals hearing. And so, let me ask you this one question, and then you can answer it in general. Has there been any judge that you're aware of who's had to recuse himself or herself because of what they said at a confirmation hearing? Can you name for me a judge who you think was biased or not able to render justice because they gave their opinion at a confirmation hearing sitting at this table as you do?
I think because the justices have followed the approach that I am following. And as I said, I've gone back and read every one of the transcripts for the justices. They have avoided commenting on whether they think decisions were correctly decided or not. If you look at what Justice Ginsburg said when she was asked whether she thought the Mayer and Harris cases were correctly decided, you will see she said, I'm not going to comment on that. She said, I know what the precedents are. I have no agenda to overrule them, and that's all I'm going to say.
She commented on many other cases, as you went through with Senator Biden yesterday and as we've gone through a little bit here. She commented on many different cases, didn't she?
My understanding...
There were reasons, but she did comment on other cases, didn't she?
My understanding of the cases she felt appropriate to comment on, as I've said, were the ones where she had already written on it. And she said, I think my writings are appropriate.
There are no cases she commented on where she hadn't written?
I thought she adhered to her view. Her view was no hints, no forecasts, no previews. That's exactly what she said. That's an exact quote from her hearing transcript.
I have to say, sir, I disagree with you. I've looked at her testimony. She didn't comment on some cases and commented on others. If you look at how many she commented on and how many she didn't, it's a far different balance than you, who have commented on Marbury, Brown, Griswold, and not much else. And each time, even when we talked yesterday about Wickard v. Filburn, and it's a 1942 case. It's at the root of it's a trunk of a large tree of constitutional law. You were unwilling to comment. And of course you say it might come before the court, but that's a prediction. Some may, some not. Some may not. Maybe a Brown case would come before the court. Maybe a Griswold case would come before the court. And if you had wanted to, you could have easily said those may come before the court and not answer those. It's sort of your own little way of doing it. I just have one more question here. The President, as I said, and this motivates some of us, he said he wants to nominate judges in the mold of Thomas and Scalia. I want to ask you, are you in the mold of Thomas and Scalia? The President said he wanted to nominate people that way.
Well, Senator, I'll give the same answer I gave yesterday to Senator Graham when he asked if I would be in the mold of the Chief Justice. And the answer is I will be my own man on the Supreme Court. Period.
I appreciate that. Do you think they are activist judges?
I'm not going to criticize them with respect to any general description of that sort. I'm sure there are cases where I would agree with them, and there are cases where I would disagree with them, as with all of the justices.
Right. Okay. Now, by the way, I'll note, I don't think I have time here, but you did criticize in a memo back in when you were working in Attorney General Fred Fielding's office, Brennan and Marshall as activist judges. Now, I don't think that was the official position of the Reagan administration, so it seemed to be your opinion. Can you tell me in 30 seconds, so I can just ask one more question, how is it different not to want to characterize Justices Thomas and Scalia, but it was okay to characterize Justices Marshall and Brennan as activists?
Well, that was it was a reflection of the views of the Attorney General at the time, and that was part of the administration
position. But it wasn't official Reagan policy.
I don't think it was official policy. It was an expression that the Attorney General had made on various occasions.
Let me just say, sir, in all due respect, and I respect your intelligence and your career and your family, this process is getting a little more absurd every time, the further we move. You agree we should be finding out your philosophy and method of legal reasoning, modesty, stability, but when we try to find out what modesty and stability mean, what your philosophy means, we don't get any answers. It's as if I asked you what kind of movies you like. Tell me 2 or 3 good movies. And you say, I like movies with good acting. I like movies with good directing. I like movies with good cinematography. And I ask you, no, give me an example of a good movie. You don't name one. I say, give me an example of a bad movie. You won't name one. Then I ask you if you like Casablanca, and you respond by saying lots of people like Casablanca. You tell me it's widely settled that Casablanca is one of the great movies.
Senator Schumer, now that your time is over, are you asking him a question?
Yes. I am saying, sir, I am making a plea here. I hope we're going to continue this for a while, that within the confines of what you think is appropriate and proper, you try to be a little more forthcoming with us in terms of trying to figure out what kind of justice you will become.
We will now take a 15-minute break, reconvene at 4:25.
Mr. Chairman, could I address some of the...
Oh, absolutely. Absolutely. I didn't hear any question, Judge Roberts, but you...
Well, there were several along the way that
we didn't want to break anyway. You go right ahead.
I'll be very succinct.
You are privileged to comment. This is coming out of his next round, if there is one.
Oh, well,
first, I guess there'll be.
First, Dr. Zhivago and North by Northwest.
Now how about on the more important subject of what
on the more important subject,
let him finish his answer. You're out of time.
Yeah. Not out of movies.
The only point I would like to make, because you raised the question, how is this different than justices who dissent and criticize, and how is this different than professors? And I think there are significant differences. The justice who files a dissent is issuing an opinion based upon his participation in the judicial process. He confronted the case with an open mind. He heard the arguments. He fully and fairly considered the briefs. He consulted with his colleagues. He went through the process of issuing an opinion. And in my experience, every one of those stages can cause you to change your view. The view you ask then of me, well, what do you think? Is it correct or not, or how would you come out? That's not a result of that process, and that's why I shouldn't respond to those types of questions. Now, the professor, how is that different? Yep. That professor is not sitting here as a nominee before the court, and the great danger, of course, that I believe every one of the justices has been vigilant to safeguard against is that turning this into a bargaining process. It is not a process under which senators get to say, I want you to rule this way, and this way. And if you tell me you'll rule this way, and this way, I'll vote for you. That's not a bargaining process. Judges are not politicians. They cannot promise to do certain things in exchange for votes. And if you go back and look at the transcripts, Senator, I would just respectfully disagree. I think I have been more forthcoming than any of the other nominees. Other nominees have not been willing to tell you whether they thought Marbury versus Madison was correctly decided. They took a very strict approach. I have taken what I think is a more pragmatic approach and said, if I don't think that's likely to come before the court, I will comment on it. And, you know, again, perhaps that's subject to criticism because it is difficult to draw the line sometimes. But I wanted to be able to share as much as I can with the committee in response to the concerns you and others have expressed, and so I have adopted that approach.
425, we're anxious to move ahead to try to conclude your testimony, Judge Roberts, as early as we can. I know you'll agree with that.
Thank you, Mr. Chairman. Sorry. Thank you for the accommodation.
Before the Supreme Court, because get out of the clock.
Just 1 second.